Yes, Mr. Canary.
My lord, my ladies, my Lord Briggs, to your question, which,
Yes.
if I may summarise it, was where is the dispute on our analysis where a case is resolved at stage 1 in the RTA protocol?
Well, the question was focused on the point where you lodged the claim form.
Yes. And
my question was, has there been a denial of justice at the point where the solicitor lodges the claim form?
My lord, yes. I want to address, I understand the question, and I want to address it in 2 parts. The first is by reference specifically to the claim form in the RTA protocol. And in our submission, even in the RTA protocol, where one lodges a claim form, a claim notification form, there is a dispute in the sense that the defendant doesn't simply agree to pay whatever the claimant seeks. Because we know from my Lord's judgment in Gavin Edmondson that there is, even at stage 1, a negotiation based on the claim notification form. There is a negotiation process where the defendants presumably push back on the claimants and seek to pay less than the claimant seeks. And that's what happened in Gavin Edmondson itself. I'm not going to take you to it now, I'll come back to it at page 830, at paragraph 60. And that's the RTA protocol. So for that purpose, we say that even the RTA protocol, there is a dispute for our purposes in that sense. But my Lord may have in mind, this was put to me, I think, earlier, both by Lord Briggs and my Lord Burrows. What about a situation where a debt claim, for example, is issued in the High Court and is instantly admitted in the acknowledgement of service? A defendant accepts liability. Question then may well be asked, where is the dispute there on our analysis? And in our respectful submission, the answer to that is given in the Court of Appeal by the approach of Lord Justice Lewison. And just stepping back, if we recall that the underlying principle is access to justice, how does one then identify where justice is being accessed? And the Court of Appeal said that is where litigation services are being provided. And that's straightforward, where a client has entered some form of dispute resolution scheme, including ADR like the RTA protocol. But it's less straightforward where the client and the solicitor are not involved in any dispute resolution scheme of any form. And in that situation, the Court of Appeal said there has to be a dispute. There has to be some form of denial of the right for the lien to arise. And the court might well ask, well, where is the logical or principal distinction between the two? Why if someone's in a dispute resolution scheme, even if the claim is admitted, does the lien arise? Because in that scenario it might be said, well, there's no real dispute. And in our respectful submission, the answer must be that in reality, where a client enters a dispute resolution scheme, there will normally be a dispute. And less important, but potentially relevant, in my respectful submission, is the fact that in a dispute resolution scheme, where a client enters such a scheme, it may be more important to have a solicitor. A solicitor may be more necessary where one is participating in such a scheme, such as the RTA protocol. Lord Burrows.
I'd like to ask you just to take us to the passage in the Court of Appeal that backs up that proposition. But can I put a wider question to you, really to test the principle? Let's just assume that we have a client who goes to a solicitor with a potential claim that involves the solicitor in a lot of work to actually work out whether they think it's justified. They actually undertake that work before approaching the other side. They then approach the other side, and the other side either immediately pays up, or says something like, we'd like more time to think and investigate ourselves. Now, it can't surely then be said that everything is turning on a denial. There is no denial in that situation. The remedy is ultimately brought about without any denial. So why is a denial absolutely essential on your view? Why, in other words, a dispute which you've defined as the denial of a claim, why in principle is that relevant?
Well, my lord, on the first of your two situations where the other side immediately pay, in our respectful submission, based on the analysis that I've outlined, there is no dispute, and the solicitor's lien doesn't bite in that situation, because since there's no dispute, there is no question of access to justice. Plainly, the solicitor has done a huge amount of work, and the solicitor ought to have some contractual protection with the client, his own client. But there's the lien, this exceptional, powerful remedy, isn't necessary or appropriate in that situation because there is no dispute. And that's my answer.
But in terms of principle, that doesn't sound very satisfactory to me. We end up with a remedy being gained after very complex work, perhaps by the solicitor, and yet you're saying that because there's no dispute, which we may have great difficulty defining, because I mean I could give you lots of other examples. I mean the other side might say, well, we never accept liability. Formally, they're never disputing the claim, but they still pay. I mean, on your view, I don't know what your definition of denial is, because we don't need a denial, formal denial, surely, in order to end up with a remedy being gained as a result of a lot of work by the solicitor.
My lord, indeed. And I wasn't suggesting for a moment that denial had to be a formal denial, still less a denial in the form of some form of court denial, as one would see in a defence. On the contrary, what I said to my lords earlier was that the question of a dispute is a question of substance, not of form. And where one identifies a dispute by reference to denial, one looks at substance, not form. So there could easily be a constructive denial. Silence. The example was given earlier about someone simply refusing to acknowledge a claim, a legitimate claim, by ignoring it. That's a constructive denial. In that situation, in my submission, the lien would arise, and so that's why one has to look at the particular facts of a particular case to identify if there is genuinely a dispute or not. And in your second example, my Lord Burrows, when you said we need more time, that's a classic example of a situation where it is too early to identify a dispute, but there comes a point where delaying and prevaricating becomes a constructive denial. And in my respectful submission, there one has a dispute and the lien kicks in. And plainly there will be situations at the margins where it is more difficult to identify whether a dispute has arisen or not. But we say that is precisely why there is some flexibility, not unlimited flexibility, but some flexibility in the way the lien is operated.
Thank you. My other issue was just if you could just point me to the paragraph in Lord Justice Lewison's judgment, I'd be very grateful. But I don't want any time spent on it, just if you could give me the reference.
Certainly. The paragraph references, and I'll come back. I'll be coming back to the judgment anyway, my lord. But first of all, it's the acknowledgement at paragraph 49 that the RTA protocol was settled at stage 1, and the analysis of Lord Justice Lewison between 56 and 58. But I'll be coming back to those passages when I address.
Thank you very much.
I think Lord Leggett has a question.
It seems to me, Mr. Kennelly, that the argument, at least in principle, so far as it hasn't already been decided in Gavin Edmondson, is about what level of assistance really the solicitor, or if it goes wider than that, other person has to provide in order to be entitled to the lien, which is an unusual thing because you'll not normally have a charge over some money that you gain for somebody else through your work. And the view against you, as I see it, is that any form of assistance in getting your legal entitlement, any form of claims handling is good enough. You say, no, to justify this recourse, there needs to be something a bit more than that. It's got to go to the level where you're actually having to recover money in the face of some opposition, as it were.
Well, yes, that last point,
Either express or implied opposition.
yes, and that last point, my lord, is key. It's the in the face of opposition, because as I tried to explain earlier in response to Lord Burrows, it's not about the amount of work the solicitor does. A solicitor could do a huge amount of work, but then when they go to secure the fruits of that work, they're told immediately, well, absolutely, here it is. And as I said, I hope clearly, that did not involve a dispute. It's not about the work, it's the question of opposition. If one is not in some form of dispute resolution scheme, then one has to ask, is there genuinely a dispute here? And often where there is no dispute, one sees the lack of a need for solicitor's assistance.
But is there also a point that there should be a dispute as a requirement, because the effect of the lien, as we've seen in the cases, is that the defendant may have to pay twice if the lien can't be enforced against the client for whatever reason, and that may well be the case in a lot of these situations, as I think we saw it's in Carnes, wasn't it, that actually the Treasury solicitors had to repay the money that they'd already paid to the claimant.
My lady, yes, and I'm grateful for that intervention, which I obviously adopted. That when I talk about the power of this equitable remedy, it's not just that it gives an extraordinary security to solicitors and priority in any insolvency, but also it can require the other side to pay twice. And that demonstrates its intrusive nature and why it ought to be granted in carefully delineated circumstances.
Can I just try one more example about, and I've got some trouble with thinking that it all depends upon the reaction you get from your letter before action. Take a situation where a solicitor A does a great deal of work and produces a humdinger of a letter before action, the result of which the other side says they've got us bang to rights and pays up. You say, no lien. Take exactly the same underlying factual claim, and solicitor B does a half-hearted piece of work and sends in a rather shoddy letter before action, to which the defendant says, no, I don't think I'm persuaded about it, I'm going to fight you. And on your analysis, solicitor B would have a lien and solicitor A wouldn't. Because
I accept
on the reaction you get back.
Well, my lord, I see how that could be an outcome, and I fully accept the situation that my lord has outlined, and I will accept that for the purposes of my analysis. But if one is concerned about uncertainty, whatever difficulty one has in identifying whether there is a dispute requiring access to justice, it's far more uncertain to base the lien on the quality of the work that the solicitor produces. And so, if one is looking for a distinction, it's better in my submission to adopt that of the Court of Appeal in this case than try and grant the lien based on or in any way by reference to the quality of the work that the solicitors produce. That is far too uncertain. But I accept, my lord, that where the lien is based on disputes, anomalies arise. But those anomalies are already in the law. We already have a highly anomalous situation where a solicitor can do a terrible job or contribute in only a very limited way to a particular piece of work, a particular piece of litigation, where, for example, the work is largely done by the insurers or indeed by expert witnesses. One can imagine in competition cases where expert economists can often contribute to a very large degree to the successful resolution of a case. And they receive no such security. The solicitor is put in a very privileged position, and that may not be justified in any moral sense on the facts of a particular case. So those anomalies are already in the system, my lord, and I'm not suggesting that we try and fix those anomalies today, but it does demonstrate that one shouldn't extend those anomalies by extending the scope of this protection, which would be the outcome urged upon you by the appellants.
Does the lien cover disbursements?
That is a question that was addressed in the Glasgow and ELS case, and my junior will give me the answer.
I'm really asking
sure
because if it does, it might pick up the expert's costs and the economic
through the solicitor. Yes, but there's a difference between having a claim against the solicitor and having your own security. I mean, I will see the answer that I get, but there is a distinction.
And could I just also ask, while your learned junior is beavering away, what happens to the client's right to challenge the amount of the bill? I mean, if the lien is operating.
The lien bites on whatever the solicitor is contractually entitled to claim from the client. So if presumably if the client, if as between the solicitor and the client, there is a dispute as to what the solicitor is entitled to, that would obviously inform the extent of the lien. But I'm not sure that's a complete answer to the question that my lady.
No, it's a practical point, because he will have lost control of the money. Anyway, anything further you can add would be helpful. Thank you.
I'm afraid, my lady, I can't answer that question comprehensively at this point, but I'll see what Mr. Coates can magic up. So the last point I wanted to make on the base on Gavin Edmondson was simply to, and again seeking to distinguish this case from the RTA protocol example. If one goes back to it at page 829, one sees at paragraph 58 the conclusion. My Lord Briggs has rejected the broader claim, which is urged upon him, which the Court of Appeal found, and he makes 2 points. First of all, he talks about the careful balancing of competing interests enshrined in the RTA protocol. And just, I'm not going to read the rest of that, but just the point here is the RTA protocol assumes that the claimant solicitor, will recover fixed costs and will receive them separately. And that's a point that my Lady Rose made earlier. The scheme here specifically envisages the claimant solicitors receiving fixed costs, which will be paid to him or her. And then secondly, one sees furthermore, this is about 6 lines from the bottom, part of the balance struck by the RTA protocol is its voluntary nature. Its voluntary use stems from a perception by all stakeholders that its use is better for them than having every modest case go to court. Now, one sees there that the scheme, which provides specifically for solicitors to receive fixed costs, which has embedded into it the solicitor's entitlement by virtue of underpinned by the lien, is accepted voluntarily by the participants. That's an important point for why the RTA protocol is a form of relatively formal dispute resolution scheme, where the rules of the game are understood and accepted by the participants. Now, what does Bott say about this question of principle? And here, although my own friend, in fairness to him, and the time available to him, couldn't cover all the points in his written case, but I do need to address them, since none of that's withdrawn. They contend that Gavin Edmondson is in fact authority for the proposition that the lien arises in every situation where a solicitor obtains money or property on behalf of his client, even non-contentious work like conveyancing or transactional work. And we say that would be a fundamental change in the law since Welsh and Hole, through Megraditchian, and even including Gavin Edmondson. There was no argument to that effect in Gavin Edmondson, and nothing in the judgment suggests the lien was intended to extend so far. In fact, in our submission, the approach of the Supreme Court in Gavin Edmondson shows that no such broad extension was intended. First, my Lord Briggs made the point that equity had to be developed in accordance with well-established principles to ensure, to use his word, predictability. But secondly, from long-standing authority, Lord Briggs identified the key justification of the lien, which was access to justice. In our submission, that principle of access to justice can't be extended without limit to all the work that a solicitor will do. Now, Bott's second argument is that if the point is open following Gavin Edmondson, then the Supreme Court should extend the lien to everything that a solicitor does, because in their submission, everything a solicitor does involves access to justice. And I'll give you the cross-reference. That's their written case, paragraph 21.6. But in our respectful submission, not everything that a solicitor does in any field, to use my own friend's formulation, promotes access to justice. That is a broad concept we accept, but it has a particular meaning. And it was summarised relatively recently by this court in the Unison case. And that was the one I mentioned to my Lord Burrows earlier when I said that access to justice normally involves accessing a court or tribunal. We accept that now that extends to ADR and dispute resolution schemes, but it is relevant in this context to return briefly to Unison, just to recall what access to justice means. And that's in the authorities bundle behind tab 32, page 1138. 1138. And I'll show you two brief passages of this. I accept this case is from a very different context. But if you go to page 1160, this, of course, was the challenge to the regulations on tribunal fees. And in paragraph 65, we see Lord Reid saying that the court has to consider constitutional principles when considering the extent of the power conferred on the Lord Chancellor. And halfway down, he says there are two principles of particular importance. And the first is the constitutional right of access to justice. That is to say, access to the courts and tribunals. And then in an important passage, he addresses the constitutional right of access to the courts from paragraph 66. I'm not suggesting you read all of that, but I will draw your attention, if I may, to paragraph 71, where Lord Reid engages more closely with this concept, because it was put to him that the question of tribunals was really a private matter between individuals, and there was a debate about the public importance of having those disputes resolved. But he said in 71, the value to society and the right of access to the courts is not confined to cases which the courts decide questions of general importance. People and businesses need to know, on the one hand, they'll be able to enforce their rights if they have to do so, and on the other hand, that if they fail to meet their obligations, there's likely to be a remedy against them. That knowledge which underpins everyday economic and social relations. And that is so, notwithstanding that judicial enforcement of the law is not usually necessary, and notwithstanding that the resolution of disputes by other methods is often desirable. So I cite that to answer my own friend's submission that everything a solicitor does, including conveyancing and transactional work, involves access to justice. Because in our submission, sale of a company, for example, or the conveyance of a building have, and we accept, economic significance, but those are purely private activities. Those do not involve any access to justice. Now, my own friend refers to the administration of an estate, and just as for a complex commercial transaction, a solicitor's assistance can be invaluable. So too to administer a complicated estate, but again, that work does not normally involve access to justice in any real sense. And there are good reasons, we say, why the lien should not be extended beyond what is needed to promote access to justice, because Bott's approach would lead to outcomes that we say could not be justified. A transactional solicitor, as I mentioned earlier, advising on the acquisition of a company, would be entitled to apply to the court for a charge over the shares, if necessary, in order for sale. He or she could block the transaction until the dispute regarding his fees is resolved between him and his own client, as Ms. Justice Rowlett noted more than 100 years ago. And we would submit it as remarkable now if that were to be the outcome as it was in 1917. And of course, if the solicitor's own client becomes insolvent, even if it's a purely transactional related debt, the solicitor takes priority in the insolvency over everybody else. And this will lead, in our submission also, to significant commercial consequences. And I do adopt the intervention by my Lady Rose and others in relation to the distortion in the market that would arise between different companies doing the same work. Solicitors are expanding, and there's make no criticism of this, into the area of claims handling, automated claims handling. But if they have the equitable lien for this work, they have a massive competitive advantage over their competitors doing the same work. Plainly, having this kind of security has a direct effect on their credit risk, and that will distort competition and ultimately reduce competition between them and other claims handling companies that don't involve and don't need to involve solicitors. There's no problem with solicitors expanding their activities into other areas of the market. But in our respectful submission, when they do that, they have to play by the same rules as apply to those other people against whom they compete in those other areas. Lord Leggett.
2 points, Mr. Kennelly. As far as the last argument goes, it's of course a two-edged one. I see the force of the point, but it can go in two directions. Either you extend the lien to others, or you narrow it for all. But in terms of transaction work, as far as I'm concerned, you're pushing at an open door when you say that the lien doesn't extend to solicitors' transaction work. I see the critical question in this case as being whether it should extend to all assistance with claims handling, if you like, when somebody wants to make a claim to get something that they're entitled to, or whether it only kicks in when where that entitlement is disputed in some way. Which I don't know about others, but I see that as being the critical point, which you've made some submissions on, but to my mind is critical to the outcome of the case.
Lord, I'm grateful, and you have my submissions on the need for a dispute. And in support of that, I say that if solicitors were to be granted this lien for doing kind of automated claims handling that we see in this case, where there's no prospect of the claims being disputed, and where there is no dispute, where they're competing directly with claims handlers. And by the way, I said there with no prospect. I don't need that. Where there is no dispute, and where they are competing directly with claims handling companies, and there are a large number of those in the market that don't need solicitors, and they genuinely don't in order to do their business. There is no justification, no policy reason why the lien should be extended to that work. And it's telling in my submission that my learned friend, Mr. Bacon, in his written case, felt the need to extend the lien to all work that solicitors do, that it's all access to justice, because presumably Bott perceives if one tries to draw a line, it becomes very difficult, because their whole plan, that the idea is to expand into other areas of business, and this lien gives them a significant competitive and commercial advantage in that area. My lord, yes.
You may be coming on to this anyway, but I'll be interested to hear what you say about his analogy with CFAs, because I understand his argument to be that their parliament has recognised that people, in order to receive their legal entitlements, need and get that access to justice in that broad sense, should be able to enter into conditional fee agreements with solicitors, and maybe others, even before it's known whether there's going to be any dispute.
Yes.
And so why should, his argument is, well, the law about liens ought to raises a similar policy consideration, and it ought to follow the principle of access to justice as it covers the scope of conditional fee arrangements. So I'd like to know how you say this differs from that situation. Maybe you're coming to it anyway, but I think that's an important point.
Yes, and my lord, I'll come to that. I'll come to it because I have to address what he says about Gaynor and the Callery and Gray case. And so I'll move on then to the second ground, because the second ground is whether the Court of Appeal erred in identifying the provision of litigation services or contentious work as the boundary for the court's equitable jurisdiction. And it's in this context that I'll deal with, in the third ground of appeal, where I'll deal with the point that my lord raised a moment ago. But on this question of why litigation services were identified as the boundary, please do go to the Court of Appeal's judgment, because I think I haven't taken you to this part of it, and it is important to see. That's in page 97. Page 97. And, sorry. And then that's the beginning, and then page 108. So you see that paragraph 49, as I mentioned earlier to Lord Burrows, cites Gavin Edmondson, acknowledges that the claims in Gavin Edmondson were settled stage 1 point. And then you see paragraph 51, he references Megadichian, taking to that, and then 52, he notes that Lord Briggs rejected the general principle urged upon him, so there must be a boundary, and he examines why equity recognises the solicitor's right to be paid. He takes the point about access to justice and says at 53, that is the key to fixing the boundary. Go to 54 then. Sorry, bottom 53. It seems to me the services that will attract the protection of equity are services of the kind a solicitor would perform in conducting litigation or controversial litigation. And then at 54, he asks, well, what are the services of the kind a solicitor would perform in conducting litigation or contemplating litigation? And he gets an indication from section 119 of the 1990 Act and the similar but not identical definition of contentious business in section 87 of the Solicitors Act. And he says at 55 near the bottom, I consider those definitions capture the essence of the principle underpinning the right. And litigation, he accepts, would also include arbitration. But then this importantly, this broad area would encompass proceedings under one of the many protocols that now exist. They are, as the judge said, highly prescriptive. Failure to comply with them may result in sanctions. And they are in effect part of an overall process under the supervision of the court. The actual right may well arise in the case of costs incurred in ADR. As the acronym makes clear, ADR is appropriate where there is a dispute to resolve, unless and until Ryanair refuses a claim, there's no dispute. So just pausing there and addressing a point made by a friend earlier, there's no suggestion that Lord Justice Lewison was referring to section 119 of the 1990 Act to limit the equitable lien to work done in court litigation only. Paragraph 56 plainly extends that beyond court litigation, obviously, beyond arbitration, to ADR, such as the RTA protocol. And he's referring to litigation services in 119 and to contentious business as a guide. He's not saying those sections set down a rule that must be which precisely delineate the extent of the equitable jurisdiction. He's using them, as he says, to capture the essence of the principle underlying the right. And these provisions are, we say, useful in indicating the boundary of the lien. If you go to paragraph 50, and submissions are made by Gaynor immediately below 56 in relation to letters before action. But in my submission, for the purposes of this point, for the purpose of identifying litigation services as the guide to whether the lien should arise, one doesn't need Gaynor, and there's no need for the purposes of Lord Justice Lewison's analysis to rely on Gaynor up to the bottom of paragraph 56. That is sufficient. What he says there is sufficient for the purpose of this appeal, and the basis for that is effectively contained in the submissions that I've set out to you earlier. But now I'll move on to the third ground of appeal and address the point put to me by Lord Leggett. What is the relevance of the operation of CFAs? And in this regard, my friend makes 7 points as to why Bott's work involved litigation services for the purposes of the Court of Appeals test. And the first point he makes is that the Court of Appeal erred in relying on Gaynor because Gaynor was wrongly decided. And my friend obviously put this at the heart of his submissions, but in my respectful submission, he's placed rather too much importance on Gaynor in this judgment, in the judgment of Lord Justice Lewison. Because if you look at the learned Lord Justice's analysis after he quotes Gaynor in 57, paragraphs 58 and 59, and those paragraphs don't depend on Gaynor. Presumably he referenced Gaynor because it dealt expressly with letters before action, but his analysis does not depend on that passage in the Gaynor judgment. It's not the plank, as my friend said, upon which paragraphs 58 and 59 rest. And if you could then look at that, the indented passage in Gaynor is referred to simply because it says that contemplated proceedings for the purposes of section 119 are proceedings of which it may be said there's a real likelihood that they will be issued. Until the potential defendant disputes the claim, it's not possible to say proceedings are contemplated, advising the client as to whether he or she has a good prima facie case in writing an equitable claim or not enough to amount to litigation services. We'll come back to Gaynor and we'll see that the CFA context we'll address the particular CFA context that my friend said was central. In my submission, the CFA point wasn't central to Gaynor, but I'll come back to that. But for present purposes, it was cited by Lord Justice Lewison simply as an example of a court addressing what are contemplated proceedings under 119. And then he goes on in 58 and 59 to reach his conclusion. This is the material reasoning, and you can read it to yourselves. I shan't read the whole 58 and 59 to you, but this is the critical reasoning of the learned Lord Justice. And the point here is, again, even if Gaynor is wrongly decided, what difference does it make to this judgment? Because even if the letter before action in Gaynor should have been treated as litigation services, it doesn't follow that the letter before action in Bott's case is litigation services. One can easily imagine a scenario where a letter before action in one context is litigation services, but in a different context does not satisfy that definition. But in any event, Gaynor wasn't wrongly decided. If you turn to tab 17, page 832, that's the beginning of the judgment. And if I could take you to 836, paragraph 12. You see the question, is the retainer a CFA? They're saying it follows that it's a CFA. And Lord Justice Dyson at 13 says he doesn't accept that. He asks, what's the object of section 58? To provide protection to clients. The need for that protection is predicated on the assumption that the solicitor will in fact provide litigation or advocacy services. If such services are not provided, the client has no need of protection. Then he says it defines CFA as an agreement providing those services which provide for his fees and expenses for those services. A provision in an agreement as to the cost paid in respect to services which are not advocacy litigation services are irrelevant as to whether the agreement is a CFA. And he says that's consistent with Regulation 1.3 of the 2000 regulations. He says it follows a central question in this case is whether the work we have done to date, referred to in the last paragraph of the retainer letter, comes within the definition of litigation services. And if you skip down to 15, you see the learned Lord Justice construing the letter. He has to do that because, of course, it's not about the work the solicitor actually did, it's about what the letter envisaged him doing. And he says that as a matter of construction, it requires a decision to be taken before proceedings are issued. And if you skip down, he adds, the phrase pursue your claim must bear the same meaning as the antepenultimate paragraph, pursue the claim through litigation. He says unlikely solicitors would have intended to waive their charges for the work we have done to date. If it was complicated, that would be substantial. And then at 16, in my judgment, he asks again the question, the last paragraph on the third page is an offer to waive fees from modest pre-litigation services. Could such services be litigation services in the meaning of the 1990 Act? And then he quotes the Act. And then he said at 17, approaching it as a matter of construction, I'd hold that the work done before a decision is made not to pursue the claim pursuant to the last paragraph is not provision of litigation services. And then he goes on to construe the statute. Now, it's not just construing a letter. He says in his judgment, contemplating proceedings are proceedings of which it can be said there's at least a real likelihood that they will be issued. Until the potential defendant disputes the claim, it's not possible to say that proceedings are contemplated. Advising a client as to whether he or she has a good prima facie case and writing a letter for a claim are not enough to amount to litigation services. But there he's construing the statute, not by reference to whether something's a CFA. He's simply asking what section 119 means. And then he says at 18, that approach to the meaning of litigation services is consistent with the statutory purpose of protecting clients. There's no need for the panoply of protection afforded by the conditions in 58.3. And he says it wasn't intended by Parliament the statutory regime should apply to agreements to provide such limited services, far from the most obvious application. And then my friend says that conclusion is contrary to, and I'll get on to paragraph 19 in a moment, but that conclusion, that rationale at paragraph 80, is said by my friend in his case to be contrary to reason and expectation. But in our submission, it's perfectly cogent. Lord Justice Dyson is making, we say, an unsurprising connection between the provision of litigation services and the resolution of a dispute. And where there's no dispute, as I've said many times, a solicitor doesn't provide litigation services. If Bott is right, my lord, that proceedings must be contemplated whenever a solicitor drafts a letter for action, the result would be that the solicitor would obtain the benefit of a lien by sending such a letter, even if the other side had said in previous correspondence with the client or solicitor that they admitted liability and proposed payment. So simply labelling a letter as a letter for action would trigger the lien, even if there was no dispute in substance at all. And that can't be right, we say. That's a victory of form over substance. Now, Mr. Friend says in his case that a distinction based on whether a dispute is based on whether there is a dispute is artificial and unprincipled, because the solicitor would have done the same work in drafting the letter for action, whether the other side accepts its contents or not. And there's an echo here of the point put to me by Lord Burrows. How is it right that the solicitor would have done the same work in drafting the letter for action, but the lien is triggered where it's met with opposition, as opposed to if it's not met with opposition? But of course, we return to the underlying purpose of the equitable lien. Its purpose is not to protect solicitors or to reward their work. The purpose is to promote access to justice. And access to justice considerations don't require that a lien should arise in circumstances where there is no dispute to resolve. And that also ties in with the point put to me by my Lady Rose. And she said, if there's no dispute, how is the work of the solicitors instrumental in producing the fund? In these cases, the evidence is that Ryanair would have paid immediately had the claimants applied to Ryanair directly, more quickly, in full, and more simply, more straightforwardly. It doesn't matter that the solicitor has done a certain amount of work, that's the point I made earlier to Lord Burrows, which they might also do if there's a dispute. What matters is the context in which those services have been provided. And now we come to paragraph 19 of Gaynor, which my friend said is the basis upon which the learned Lord Justice took the analysis which went before it. And what the Court of Appeal says in the paragraph 19 is that the retainer letter has been drafted with care, it increases access to justice, it says it's basically beneficial, and it says it'd be unfortunate if such retainers were to be unenforceable because they were CFAs but didn't satisfy all the conditions imposed by the 1990 Act and the 2000 regulation. Now, my friend says the need to render the retainer enforceable was the basis for the whole judgment. But we say that's not a fair reading of this judgment. Even if, in fact, the CFA would not have been rendered unenforceable for some other reason, in my submission, Lord Justice Dyson's earlier reasoning would have been the same. The reasoning which he sets out between paragraphs 14 and 18 doesn't depend on the need to keep the CFA or the need to avoid it being a CFA and keeping it enforceable. But so in my submission, that point 19 is a postscript which is not material to the earlier conclusions. And as we say in our case, and there's no need to take you to this, it's not clear that my learned friend is even right that there would have been an enforceable CFA in any event, because, as you can see from our case, that would require the retention letter, the retainer, to be signed by the client. That's what section 57.3 of the Solicitors Act requires. But from paragraph 6 of Gaynor, it's not clear that the client care letter was in fact signed.
I think Lord Leggett has a question.
Sorry.
I don't actually see, Mr. Kennedy, why it matters a row of beans whether Gaynor was correctly decided or not in this case. We're not here to argue about whether it was an enforceable CFA or not. All that matters is what are the underlying policy considerations which drive the lien, and whether they map onto or don't the policy considerations which justify the scope of a CFA being enforceable.
Yes. Well, okay. Now I come to Callery and Gray, and here I hope to address the point which I'm sure Lord Leggett is waiting patiently for me to address on the relevance of CFAs, and I'll address that in.
Well, not so patiently. I'm sorry about that.
Sorry. I'll move on to Callery and Gray. I'll move on to Callery and Gray then, hastened by that intervention. So Callery and Gray is in the Supplemental Authorities bundle, and just to get to the point, my lord, in our submission, the points here about CFAs don't map on to the scope of the equitable lien. CFAs serve a number of purposes. It includes access to justice. It's not limited to that. And those considerations are not exactly the same as those which are relevant for the purpose of delimiting the equitable lien. And so although my friend seeks to say that the fact that one can have a CFA for non-contentious business is the answer to this case, in our submission it simply isn't. It doesn't map on in that way. Access to justice is the principle underpinning it, but then one has to look at how the lien should be properly delimited to be consistent with authority and to avoid the distortions which I outlined earlier. And one doesn't have a safe analogy from CFAs. And in Callery and Gray, we see that the real question here, as you saw, was whether it was reasonable for a claimant to whose RTA claim was settled pre-action to recover by way of costs a success fee and an AT insurance premium. So these cases are concerned with the reasonableness of costs recoverable between the parties under CPR Part 44, and not with the definition of legal services under the 1990 Act. And it's true, the Court of Appeal said that in principle it was reasonable to recover these costs from defendants, the success fee, even where it was unlikely there was going to be any real dispute as to liability and quantum. But in my submission, the reason for that approach was specific to this regime of CFAs and ATE and personal injury cases, and cannot be read across to our case with Bott. And you get that from paragraphs, I may take you to them, 92 and following. So first, in Callery and Gray, in the Court of Appeal, page 22 of the Supplemental Authorities bundle. And the Court of Appeal says at 92 first, in considering this issue, we think it's right to bear in mind the purpose of the new regime. The first purpose is to facilitate access to justice on the part of those who cannot afford the cost of litigation. Again, litigation here is important. And you have my submissions about what that means in this context. It means a dispute resolution scheme or dispute if you're not party, if you're not in such a scheme. And the second purpose is to, and this is really important for my submission, is to reduce the burden of legal aid in relation to certain categories of case where it was previously available. 93, including success fees and recoverable costs, of the general effect of shifting from the legal aid fund to defendants or their insurers the costs incurred by litigants whose claims fail. In the first instance, the claimant's solicitors shoulder the risks in relation to these costs, exchange for uplift. The fact that the uplift in successful cases is transferred to the unsuccessful defendants results and takes a global view in the burden of unsuccessful claimants' costs being borne by unsuccessful defendants. And then at 99, they see the force of the submissions the defendants made, that it's not fair to saddle them with these costs well, without giving them a fair chance to identify those cases, my learned friend places heavy reliance on that. But 99, we've concluded that, at least in the circumstances of the two appeals, the prejudice to defendants is not as clear as suggested and is outweighed, importantly, outweighed by the legislative policy and by a number of practical considerations. So, 1, if the new regime is to achieve its object, the legal costs of claimants whose claims fail shall fall to be borne by unsuccessful defendants in the manner described in paragraph 93 above. And one sees there the reference back to 93 and echoing 92, that because legal aid was being withdrawn from these cases, the policy choice was to transfer the burden from the legal aid budget to unsuccessful defendants. And for that to work, you had to penalise the defendants in this way and subject them to this prima facie unfairness, which is summarised in their submission 98. And 2, if the latter alternative is adopted, the defendants who could test liability will not share liability for costs in a manner which is equitable, where the strong defence which is reasonable to advance a larger uplift would be appropriate than when a defendant unreasonably persists in contesting liability despite the fact that defence is weak. Thus, the more reasonable the conduct of the defendant, the larger the uplift that they have to pay if his defence fails. And if I may skip down then to little 9, another important policy consideration which distinguishes this case from our case. There is overwhelming evidence from those engaged in the provision of ATE insurance that unless the policy is taken out before it is known whether a defendant is going to contest liability, the premium is going to rise substantially. Indeed, the evidence suggests the cover may not be available in such circumstances at all. And that's a critical point. If these policies can't be covered before the dispute arises, there's going to be a real problem in getting them. And the availability of AT insurance is the cornerstone of the legislative policy choice to shift the burden away from the legal aid budget to unsuccessful defendants. And my lords, that is a critical policy and legislative policy issue. And in fairness, my own friend, he rather skipped over that when he took you through Callery and Gray in the Court of Appeal earlier today. But we distinguish it on that basis.
Mr. Kennedy, can I just check? We're here looking at a balance trying to be struck on policy grounds, where if the CFA process is available, it does increase the cost burden on the defendants. But if the lien is available here, and everybody in the industry knows that the lien is available here, its existence in the airline delay claims environment, where there's no added costs, won't in fact increase any burden on defendants at all, will it? Unless, knowing of the lien, they act inconsistently with
it. On the contrary, my lord, the consequences of the lien, in this case, produce enormous inefficiencies because they incentivize the solicitors to generate, and I'll come to the evidence on this when we address the work that Bott actually does. That is part of the case. So this is not just pure prejudice. The availability of the lien and that security encourages solicitors like Bott to generate unnecessary litigation and unnecessary work to resolve cases which are extremely straightforward. And they know that even if they have trouble getting the money from their own clients, well, it won't arise at all because they expect to be paid directly. But if an airline deals with the passengers directly, they can force the airline to pay twice.
Yes, so if the lien is known about by the airlines, so they do pay the solicitors directly, the only person who suffers surely as a result of unnecessary work being done is the client, because the solicitor's bill comes out of the client's fixed payment. And
my lord, yes, but the problem is, the evidence is that the passengers who expect to get their 250 or 400 euros receive 2/3 or half of that.
Yeah.
And they blame the airline. They blame the airline because, as far as they're concerned, it's the airline that pays out the money, and they don't understand why they get so little. And Ryanair's evidence in this case, the reason why Ryanair is fighting these cases, because they have a relationship with their passengers in repeat business, and passengers are understandably upset when they receive a fraction of the compensation which they're entitled, and Ryanair's reputation suffers as a result, even though in reality it's not Ryanair's fault. And that's Ryanair's evidence in this case, and it's recorded in the judgments of the courts below. So there's a policy concern about extending the lien in areas like this, which don't involve a dispute in any real sense, because it does generate inefficiencies and waste. And so there is a broader policy consideration to that extent.
And it would follow, wouldn't it, if there's additional cost to Ryanair, which it ought not to be paying because it's having to pay extra fees, that the costs will be passed on to the passengers who do not make claims.
Precisely, my lady. And the evidence from Ryanair is it's not just that the passengers get less money than they're entitled to, and Ryanair's reputation suffers as a result, but Ryanair's administrative costs and internal costs are obviously increased when it's dealing with letters before claim and threatened proceedings, as opposed to an almost instantaneous process through their own online portal, which I shall take you to. And I will address the point I've been a friend that Ryanair sends its poor passengers away to fill out lots of forms. You will see the form that their passengers are asked to complete. So if I may, my lady.
Can I just clarify? We have to bear in mind that, of course, that the lien applies in all sorts of cases, not only where there's a CFA. And in fact, I should imagine the lien is very valuable in many cases where people just, rack up the fees and there's no CFA, which makes it curious that this CFA test, if that's what it is, I'm not really quite sure what section 119 definition, what it's tied to. It doesn't seem actually to be tied to the CFA because Mr. Bacon had shown us section 58A4. So we're looking at 119 slightly in a vacuum, and I'm not quite sure what your case is about whether that is a helpful definition to look at, whether it's anything to do with CFAs or not, and if it's not, then where you express the dividing line as being.
So my lady, section 119 is there in order to give meaning to, so forgive me, I can give you the answer to the first point. Section 119 was inserted to give meaning to the expression litigation services in section 58, which was inserted to permit CFAs. So the definition was given there in order to give meaning to a provision dealing with CFAs. So there is that link to that extent. However, in my respectful submission, the reference litigation services in the judgment of the Court of Appeal in our case was given as an indication of how one draws the line for the purposes of the equitable lien. It was not to cite section 119 as the rule or the test that has to be satisfied in every case. That's why Lord Justice Lewison referred to the essence of the principle, and that's why, my lady, it is useful to that extent. But one must be careful about placing so much weight on it, as my learned friend Mr. Bacon has done. It wasn't intended to have any broader purpose beyond providing that useful indication by analogy, and that was what Lord Justice Lewison plainly had in mind. And we respectfully agree and rely on it to that extent, but not more than that. And we say that the reference to CFAs and the attempt to read them across just isn't there in the authorities. Mr. Bacon took you to Callery and Gray and said, this is the fundamental authority, this is the answer to the appeal. And we just don't see that. I may be missing something, my lady, but my submission is Callery and Gray can be distinguished, and perhaps we'd all be grateful if it answered the appeal, but it just doesn't. And the read across on the basis of CFAs isn't there, and we say it doesn't need to be. The dividing line is drawn by Lord Justice Lewison and by reference to the principle of access to justice and the need to properly limit the lien because of the consequences that arise if it's extended too far. And he's done that on a principled basis, which is based on a dispute. And on the third round of appeal, having addressed Gaynor and Callery and Gray, the third point that Renfrew made, I said there were 7, was that the Court of Appeal failed to appreciate that pre-action business may become contentious once proceedings are issued. As my lords have read paragraphs 58 and 59 of the Court of Appeal, that's exactly what Lord Justice Lewison said. But here, no proceedings were issued. Now, I fully accept, and I think Bott does too, that work carried out before proceedings are done can be converted into contentious business once proceedings are issued. The pre-action work becomes contentious business once the proceedings are issued, because then one can see that proceedings were in fact commenced. But under Section 87 of the Solicitors Act, the definition of contentious business doesn't apply unless proceedings are in fact commenced. And the 4th, 5th, and 6th points that Bott makes to say that their case is on all fours with the RTA protocol, I will take together. And in my submission, the RTA protocol and a claim made under it are not comparable at all for claims for compensation due under Regulation 261. We saw the RTA protocol and the detailed voluntary dispute resolution scheme that it contains. You have my point that the value of the claims goes up to £25,000, claims that would otherwise litigate in a formal sense. And I can show you that a claim made under it is not like a demand under 261, Regulation 261/2004 at all. And I'm asking the court now to recall what I showed you in our written case at paragraph 79, the long list of things that need to go into the claim notification form and the statement of truth. And I'd like to contrast that with what needs to be given by a passenger to make a claim under EU 261. And you see that in Ryanair's online claim form, which is in the core bundle at page 617. So I'm in the core bundle at page 617. Now, this is Ryanair's claim form. And as you can see, unlike the claim notification form under the Road Traffic Act protocol, all that's required from a passenger is his or her name, email address, the reservation number of their flight, and the last 4 digits of their card, so that the payment can be made to them. And you have already seen from the statement of facts and the judgments below the much more involved process that Bott undertakes in order to procure the same result. And in our submission, as we said below, that is completely unnecessary work. The nature of the regulation, the nature of the claim under it, is for effectively automatic compensation of fixed sums. There is no negotiation, there's no debate about quantum. If certain very limited conditions are satisfied, the payment is due automatically. And the fact that there are fixed sums in issue is not in dispute, and I'll give you the reference. It's in the Statement of Facts and Issues at paragraph 9. I was asked the question by Lord Briggs earlier, how does the obligation to pay under the regulation crystallise? Does it require a judgment or an award? In our respectful submission, the answer is no. The regulation provides that the airline shall pay where there has been a cancellation or, as we know from the Court of Justice in Sturgeon, a delay of the relevant time.
My question was whether, Mr. Key, my question wasn't whether it required a judgment or an award, but whether it required a demand. So whether it was respective, even if not demanded by the passenger.
So there is no requirement. The regulation is silent, but there is no requirement that the airline must proactively issue payments to passengers in respect to their rights under the regulation. Now, Mr. Bacon said that means the solicitor is needed to vindicate the passenger's rights. But the solicitor is no more needed to vindicate the passenger's rights than the passenger needs to fill in the form that is still before you at page 617. The passenger needs do no more than that. And in fact, what the solicitor requires, what Bott requires the passenger to do is far more than Ryanair requires the passenger to do in this form at page 617. And my learned friend says, well, the reference to a mechanical and formulaic process in the judgment of Justice Lewison is unfair because technology is a good thing. But the reference to mechanical isn't a criticism of the use of technology. It's the legal input that's mechanical. The legal input to the computer program, which my friend relies upon, is manifestly extremely basic, because the obligation of the regulation is so clear and straightforward, and the exception to the obligation to pay is so limited, that a form such as this that you see here is all that's required. And as you saw in the evidence, Ryanair pays between 1 and 2 days, and obviously the payment is made in the full amount. And my lady Arden made the point earlier about, what about the consumer? Does the solicitor save the consumer anything or any work, any effort? The opposite is the case. Bott contrives to generate a complicated process, and the consumer is far better off going to the airline directly. It's a much more straightforward and swift process. Another friend said earlier, well, Ryanair just sends the passenger off to fill in all the forms. I took a note of what he said. This form, page 617, is all the passengers required to complete. And if my other friend was suggesting that in some way Ryanair doesn't respond to these forms and somehow doesn't have a good reputation or is known not to pay, he didn't say that expressly, but if that was the suggestion, Ryanair is audited by the Civil Aviation Authority in the United Kingdom, as are all airlines, in respect to their compliance with EU 261. I'm not going to turn it up, but I'll give you the reference. And Ryanair is assessed as very good in relation to its compliance record with EU 261. That's in the core bundle, page 572. The CAA compliance report begins at 568. So, but the important point here is that, I'm sorry, Lord Burrows. Yes.
You've referred to a few times to the evidence. I'm assuming you're referring to the first instance judgment. Is that right?
Yes.
Is all the evidence that you're referring to contained in that judgment?
My Lord, no. It's everything's in that judgment apart from the pages that I take you to directly in this hearing. So I'm relying on the documents which I've taken you to and to the first instance judgment, which are consistent with what the first instance judgment says.
Yes, the only document you've taken us to is this one, though, isn't it, at 617?
Absolutely. I'm taking to a bare minimum of other documents. I'm relying, obviously.
I mean, what I'm quite... is there any evidence, for example, in this form, we're told that if the delay or cancellation was unexpected and therefore outside of our control, no monetary compensation is due. Is there any evidence about how often that issue is in play and what then happens?
So I don't think there is. Again, Mr. Coates will correct me. I don't think there's any evidence dealing with the proportion of claims which are said by the airline to be covered by extraordinary circumstances. But you will see that, you will have seen from the evidence, from the statement of facts and issues, and from what from the judgments below, that the portal that Bott operates identifies automatically the whether the weather conditions or other very limited bases for extraordinary circumstances are such that the claim would be unsuccessful. Bott itself weeds out those extraordinary circumstances situations through its automatic portal. And I should know from bitter experience, my Lord, that the basis, the Court of Justice has construed the extraordinary circumstances exception extremely narrowly. And so in reality, it's strict liability absent.
That's a fairly recent decision, I think, is it? Or am I wrong about that?
No, my Lord. There's a very recent decision confirming that. But it's been a well-established principle for a long time. I reference the fact that it's a consumer protection measure, and any exceptions to it must be narrowly construed.
Yeah.
But if you're asking, my Lord, what evidence is there as to how often these claims, how often they succeed, in the sense, how often does the airline successfully raise in extraordinary circumstances defence? Bott itself said that it has a 99% success rate. And I will take you to this document now, since you have the core bundle. And that's at page 573 of the core bundle. (573). This is a Bott document. Now, it was adduced to Ryanair's evidence, a point taken by Minerva Friend in his case, but at no stage in the last several years of litigation has Bott disavowed this document or sought to explain it away as an error or an exaggeration. Bott says in terms that they're the UK's #1 flight delay compensation service, and they have a 99% success rate. Now, what normal firm, we ask rhetorically, could say that? It shows that this is not a normal law firm doing normal litigation. The reason why there's a 99% success rate is because these are claims that are so straightforward. There's no need to go to solicitors in the first instance. And the evidence in the statement of facts and issues is that Bott commences roughly 1,100 new claims against Ryanair alone each month, 50 claims every day, and 3,000 a month overall against the airlines collectively. And if you look in the High Court judgment, prompted by Lord Burroughs, I will now take you to that in the key bundle, and you have that page 120. Page 120 at paragraph 18. You see that Bott's online tool confirms to the prospective client whether she has a prima facie, whether she's prima facie eligible for compensation of the regulation. That's having checked in the computer program a database of weather reports. You have that in the previous paragraph 17. The client's then invited to provide other relevant information online, including contact details. And none of this, it appears, involves manual intervention by anyone at Bott. And then 19, the prospective client confirms that she wishes to proceed with her claim. She gets an email. She sent certain documents. And then at 20, in the first human intervention, one of Bott's paralegals manually checks the claim to verify whether the claim has more than a 50% prospect of success. That takes about 2 days. If it's accepted, Bott says it's willing to accept the case on a no-win, no-fee basis. The claim is successful. Its fees will be 25% plus VAT of the total compensation, plus an administration fee of £25 per passenger. That'll be deducted from the compensation before Bott pays the compensation. And then at 21, having accepted the claim and confirmed the instructions, Bott sends a letter for action in a standard form to the relevant airline, seeking payment, response in 30 days. And at the bottom of page 121, you see that the same letter may cover a single claim or multiple claims relating to the same flight. It's very common for a single letter to cover a family, for example. So one could have a family of 5, each entitled to 250 or 400 euros each. And Bott will regularly claim its fees up to the cap for each of those passengers. And then at paragraph 95, according to Mr. Benson's evidence, Mr. Benson is the solicitor for Bott. There are 24 staff dealing with flight delay compensation claims, but only one solicitor, himself, and 2 litigation executives.
Mr. Keneally, you're getting quite near your time limit.
I am indeed, I'm coming to the end. So we say that, as I said earlier, Bott's work is a million miles from the work that the solicitors have to do in assisting claimants in the RTA protocol and in completing the claim notification form, as you have seen. The last ground that I need to address you is whether this remedy is discretionary. you will have seen that this is an issue raised in the 4th ground of appeal, where it said the Court of Appeal erred in saying that there was a discretion to exercise in deciding whether or not to apply this equitable lien. And that's paragraph 33 of the Court of Appeal's judgment. And I'll just show you that, and this won't take long, because in our respectful submission, there's nothing between what the Court of Appeal said here and what my Lord Briggs said in Gavin Edmondson. So 33, having referred to the same authorities, it's a right to ask the court to exercise a discretion in his favour. Lord Briggs said the right is better analysed as a form of equitable charge. Lord Justice Lewis says, I don't consider he intended to cast doubt on the well-established principle the right is the right to ask the court to exercise a discretionary power. And we say there's no error in that. And we say that this is not a case where the court should exercise its residual discretion, even if you're against me on the submissions I've made. In view of the work that Bott does and the nature of the exercise, you shouldn't exercise your discretion to grant them the lien. They do little or no work in the cases with which this court is concerned. And in fact, their entitlement to fees arises only because it involves itself disproportionately, we say, in straightforward compensation cases. And they fail to advise their passengers to claim directly, which is obviously in their best interest. They actively discourage their clients from contacting airlines directly. I'll give you the reference. That's in our case, Respondent's case, paragraph 102.3. As in the statement of facts and issues, they acknowledge that the average claim is £327, and their average fee, their average recovery is £95. That's Bott's own evidence. And we say this is a serious matter that goes to the exercise of discretion. I'll give you the reference, and I'm coming out to the very end of my submissions. The reference is in the core bundle, page 626 and 628. In fact, if I very last thing to show you, and this is the SRA guidance, and this is why we say that this is something serious, and this is why the discretion should not be exercised in particular. You have the rest of the reasons in my case, but here we say what Bott is doing is actually very serious. They are not satisfying their duties to their own clients. The SRA guidance on the balancing of duties in litigation is in the core bundle at page 626. At 628, second column at the very bottom, they refer to excessive litigation. And over the page at 629, we've seen instances where the solicitor fails to act in their client's interest, predatory litigation, where the clients are induced to proceed with litigation where there is little or no legal merit, or, and I rely on this, where litigation is not actually required. And over the page at 630, predatory litigation involving clients are schemes where clients are induced to incur unnecessary legal costs. Visible examples have arisen from governmental, statutory, or regulatory compensation schemes with the involvement of litigation, or in some cases any legal professional, was essentially not required at all for the majority of claimants. And that's an important regulatory issue, which we say is being flouted by Bott in this case. And I'll give you the very last reference. I won't take you the document. The European Commission, at page 622, has said in terms, 622 of the core bundle, that passengers should go directly to their airlines in the first instance to claim their EU 261 compensation. And there is no need to go to solicitors' firms at all, or pay a penny of solicitors' fees in making these kinds of claims. Unless I've got anything further to say, those are my submissions, my lords and my ladies.
Thank you very much, Mr. Kennelly. Mr. Bacon. Mr. Bacon?
Can you hear me okay?
Yes, we can now, thank you.
Sorry, some technical issues there. Coming back, if I may, to the portal and the RTA protocol that was the subject of the Edmondson case. No different referred on more than one occasion to the portal as a form of arbitration scheme for the resolution of disputes. My Lord, it's put in place to resolve claims which are not disputed. It's absolutely vital that that is understood. If a claim is disputed in the portal, it exits the portal and goes to court. So it's not an arbitration scheme. It's not a dispute resolution scheme. It's a mechanism through which undisputed claims can be determined, resolved. And
well, Mr. Bacon, isn't it slightly more complicated than that? The portal scheme, as I understand it, is to resolve claims which are not disputed as to liability, but it commonly involves negotiation about quantum.
it's where negotiation on quantum is required and where quantum is not agreed. Yes, you're right. You can really resolve any questions of quantum within the portal, but there are cases where there is no dispute on quantum. You can put a claim in. You might have, a £30 claim for special damages or something, which is undisputed, and a claim for general damages, which is undisputed, and the matter compromises with the payment of the adverse costs. So it's capable of and designed to deal with wholly undisputed claims and partially disputed claims, if that's a fair analysis in terms of the quantum. If liability is disputed, it exits. Yes, my lady.
But isn't there another difference, which is that it's voluntary, so that if an insurer or a defendant doesn't want to be involved in it, they don't have to, whereas your way of dealing with disputes is not voluntary. Ryanair doesn't want to engage with you in this matter and have its clients subject to your fees. Isn't that an important difference between the RTA protocol and this case?
Well, it's not actually voluntary. I mean, this is a process enshrined in the court procedure rules, which is specifically set up for the parties to these sorts of disputes to engage in. It started as a voluntary. The whole system started as a voluntary collection of both sides of the industry coming together to create a scheme under which they could enter. But if you've got a personal injury claim and you instruct a solicitor is instructed in respect of the claim, the solicitor will commence the proceedings under the portal. In fact, if you don't comply with the portal or with any other practice directions, you can be criticised for that later on, my lady, in terms of sanctions and costs. So it's wrong to treat it as voluntary in the sense that you asked, with respect. It's the same in that sense as any other of the protocols. And indeed, if I could just take you quickly to page 1228, we haven't looked at it, but 1228 is the protocol that Bott, the practice directions protocols that Bott complies with, which we haven't looked at yet today. 1228. This practice direction, it starts at 1225, applies to these airline claims. It's called a pre-action conduct protocol, and you'll see it states in the introduction that it explains the conduct which the court would normally require and expect parties to take before commencing proceedings of particular types of civil claims. And they're approved by the Master Rolls and so on. And in paragraph 2, the practice direction applies to disputes where no pre-action protocol approved by the Master Rolls applies. And that applies here. The objectives of the pre-action conduct and protocols are then set out in paragraph 3. And at paragraph 6, there is the requirement at 6A to comply with the protocol before commencing proceedings. Where there is no relevant pre-action protocol, as here, the parties should exchange correspondence and information to comply with objectives in paragraph 3. The steps will usually include A, the claimant writing to the defendant with concise details of the claim. And that's, sorry, my lord.
You read out a paragraph, it says this practice direction applies to disputes. Doesn't that beg the question? I mean, Mr. Kennelly's argument is that where there isn't a dispute, the lien doesn't apply, and by the same token, it might be said the pre-action protocol doesn't apply.
No, Lord, take a point, but the word dispute has to be looked at in context of paragraph 6A, which is that you don't identify the dispute until you've written to the other side.
Well, maybe, but I mean, on your approach, any time you want to ask anybody to pay you something, you can write a letter and call it a pre-action protocol letter and say I'm operating under the pre-action protocol. But you know, it's self-fulfilling that way.
Well, in fact, my lord, that is the position. If you want to claim a debt claim or any other claim that you have a legal entitlement to, although it may not be disputed at the point you first liaise and correspond with the opponent, you're required to set out in writing the details of the claim, including the basis for the claim as it's made in paragraph 6A, and the defendant then responds in accordance with the protocol to identify the disputes which are identified in 6C.
But Ryanair
It's some really straightforward scheme which is entitled to hand out money compensation to people, and you come along as the claims handler or solicitor and you write a totally unnecessary letter before action because you want to generate some fees, and then you can say, oh well, this is I come under the pre-action protocol, so I'm just doing what the court tells me to do, so I thank you very much, I'm entitled to my £100.
Well, my lord, with respect, what one sort of starts from a slightly, these are all cases in which the claimants have chosen to instruct Bott to pursue their claim that they believe they have. They don't have to. Nobody's saying that the claimants are required to use Bott. They've taken a decision to employ the services of a third party for reasons that are likely to be varied, but entirely personal and justified. And in those circumstances, the solicitors are required to comply with the protocols that apply, and that includes this practice direction that I'm currently bringing to your attention. So it's to pose the question on the basis that they're sort of creating an unnecessary process with respect is to underplay the role that the client is actually playing here, which is that they choose to instruct the solicitors to take the proceedings for them on their behalf rather than do it themselves. Of course, they may do,
but if the solicitor knows that 99% of the time the airline's going to pay up, is it really necessary to lay the ground for a potential civil claim by writing a pre-action letter?
Absolutely, it is. The same thing will apply in all of the litigation. I mean, we have the same statistics in personal injury claims across the country, Lord. You know, 99% of claims settled. But they all start with a process of a letter of claim. In the low value claims that we're looking at in colour in grey, except the large value claims don't. The low value multi-action RTA claims to which the protocol is intended to apply are indeed all premised on the basis that they all likely to settle, and so you know the comparison, the analogy is a good one with this sort of claim. Most of them do settle, not all of them do. And if they don't, obviously they go forward, and the letter of claim, in the absence of one, would be taken as a criticism. No doubt later on. You'll see from paragraph 13 of the protocol compliance with this practice direction and the protocols. If a dispute proceeds to litigation, is the language used in paragraph 13.
Well, wait to see whether they pay up or they don't, and if they don't, you can write a pre-action letter.
Well, we would submit that writing the pre-action protocol letter is a perfectly legitimate step to take in the process of recovering compensation. The issue here is whether, once you've undertaken the work, Ryanair will notice that the work is being undertaken through the instrumentality of the solicitor at the client's request, whether Ryanair should still nevertheless be entitled to pass the recoveries that have been instrumental through that solicitor's energies to the client. And just to make good that point, the contractual position, if one just looks at the agreement, again, we haven't looked at it in the short time I've got, I just draw your attention to what the clients ask Bott to do at page 469 of the bundle. they agree under the heading dealing with costs if you win, paragraph 10, you agree to pay into a designated account any cheque received by you or by us from your opponent and made payable to you. Out of the money, you agree to let us take the balance. And so the clients here are doing two things. They wish to instruct somebody else to do the work for them, and they wish to, and they're happy and content for the recoveries that have been made by the instrumentality of the solicitor to be deducted in terms of the charges.
And when they make that choice, which they're happy to make, does Bott draw to their attention that they have the alternative, if they wish, to fill in the form online and avoid Bott's charges?
Yes, I'm instructed that they are. First of all, there's a cooling off period. So
now, I'm not asking about a cooling off period. I'm asking whether Bott points out to the client, you can either go with us and fill in our rather complicated form and pay us 25% of your recovery, or you can fill in the other Ryanair form online, which is much simpler, get the whole amount if your claim's not disputed, but you won't have the benefit of our services if you have to go to court. Is that choice all explained when they take this free election?
I'm just waiting on instructions from that, my lord. I'm not sure it's put in that way.
Well, is it put at all? That's the question.
462. I'm told there's some claim use page 462. There's part of the exhibit to one of the witness statements. 76% of people we surveyed had been refused compensation or ignored by the airlines when they had valid claims, according to our records. Claiming yourself can be a long, laborious and stressful experience based upon doubtless the experience. Those who do succeed in getting a response from airlines can end up paying for the privilege to represent themselves in small claims called against airlines.
You say that's a fair presentation of the alternatives, do you?
Well, I'm saying that's what's...
that's positively misleading, isn't it? It's actually making your case worse. There's the 76% there and the 99% with Bott. I mean, they just don't add up, really. I know they strictly do because these are the people you've surveyed, but it's possible that the figures are reconcilable. But it's hardly presenting the facts in a fair way, is it?
Well, you have what I've said, my lord, in response to that. I mean, as I say, the issue here is where clients have instructed. I mean, I would say the caveat about Malone and Friends sort of summary of the so-called evidence. This is a Part A claim brought below. There hasn't actually been any testing of the evidence below. So one has to be somewhat careful about statements made by both Ryanair and by us on either side.
Oh, I know, but you're putting your best foot forward in showing us this piece of paper.
I perfectly accept that. I perfectly accept that. But on the issue for the court, with respect, is on the assumption that customers of Bott & Co. willingly and freely and wish Bott & Co. to pursue their claims through this form of process. Does equity come in to save the solicitor the time, trouble, inconvenience to both the solicitor and the client of having to either seek a payment up front for the costs involved, which would inhibit the claim going forward, an access to justice point, or pursue the claimant after recovery because Ryanair refuses to pass the compensation directly back to Bott. And it's against that background, with respect, I would submit that the Supreme Court ought to consider the legal question and answer it in that context, because there is a danger of otherwise infecting the outcome by reference to prejudicial comments made in the absence of a proper and fair consideration of what is really happening on the ground from either the consumer's perspective or Ryanair's perspective, in fairness to Ryanair. My lord, just coming back to my reply points, the Ormerod and Tate case, if I may, it's at tab 28 for your notes. But Lord Kenyon, in giving the judgment to the court, said that the underlying rationale for the rule, he referred to three things: convenience, good sense, and what he called the justice of the thing. Now, in our submission, where a consumer has requested a law firm such as Bott to pursue its claim for it, where it is agreed that Bott can take its charges from the recoveries, where Ryanair is not being asked to pay any more than it would be required to pay were the claim being brought by the consumer direct. The convenience, good sense and justice of the thing screams out, we would submit, for the proposition that that Ryanair should provide for the charge. In other words, should ensure that it respects the legal charge that arises as a result of the instrumentality in the solicitor's endeavours on the consumer's instructions. So far as some of the points made in the course of argument, my Lady Arden raised the question about what about the consumers, the cost to the consumer. The consumer here has a right to challenge, dispute the legal charges if the consumer wishes to do so. So questions of overcharging by Bott or by anybody else are met by the law in a different place, namely the Solicitors Act. And so the principles applicable to the lien should not be swayed one way or the other by reference to concerns about overcharging. They are met through the ability of the client to challenge the deductions that are made by the solicitor to the recoveries. Sorry, my lady, you're on mute.
I think you're on mute.
That's it, got it now. So the client will be informed of his rights to challenge the bill.
Yes, that's contained within the paperwork that the client receives.
Okay, thank you.
Reference to that in a moment, my lady, but that is the position.
Thank you.
In answer to my Lord Briggs' question, are disbursements covered? Yes, they are. The reference for that is paragraph 54 of Glasgow. So that does deal with the experts' point. The Glasgow case itself, and Mr. Kennedy's submissions about insurers, I mean, that case is miles away from where we are today in respect of this case. An insurer who's insuring a claim or insuring the adverse cost risks of a claim is not instrumental in the recoveries. It's in one sense, it's a little different from the position of the expert who might provide significant evidence to support the claim, but isn't instrumental actually in its recovery, because it's the solicitor in the context of the lien who is instrumental in the recovery. It's the solicitor who pursues it on behalf of the client. And so one takes little from the fact that in Glasgow, the court held that there was no lien for the insurers. And so far as the extension...
Sorry, I saw in section 73 of the Solicitors Act, that also introduces this element of instrumentality of the solicitor's work and the charging order that the court has the discretion to impose. And I wondered whether you knew if there was any case law as to whether that concept involves any kind of causal but-for link, or whether it's simply a question of the quantitative nature of the work. Is it any kind of significant work, or does it have to be work which prompts the money being paid over in a causal way?
Well, the answer, in my personal suspicion of that, lies in the Supreme Court's decision in Gavin Edmondson. The principles underpinning the Section 73 charge are unlikely to be any different to the principles underpinning the actual charge in the sense of instrumentality. And there, as my lady knows, so long as the solicitor has been instrumental to a significant extent, is the language used. And on the facts of the case, the significant extent on Edmondson was simply the lodging of the CLF form, because in one of the cases there had been the lay client, so to speak, the consumer, had been on the telephone to the insurers and had negotiated his own settlement. There was a small increase in that following the lodging of the CLF by Edmondson, but on any view, properly analysed, their input was significant in terms of recovery, but in terms of the input, it wasn't terribly significant in terms of the amount of time and energy expended, if you see what I mean. In that case, it settled immediately following the lodging of the CLF in stage 1. There was little more for the solicitor to do except fill the form in. And so the Supreme Court has confirmed the test is whether the solicitor concerned or the party concerned who is seeking to apply the charge, here the solicitors, has undertaken work which was instrumental to a significant extent to the recovery. And we say that plainly must arise in circumstances where the only party, the only dialogue with Ryanair was with or through the solicitor, and it was through that dialogue that the recoveries were made, that there is self-evidently instrumentality in the recovery. But the fact that the client could have secured a settlement direct, or the fact that some other firm could have achieved the settlement, is neither here nor there. It's once the consumer has decided to use the services of a solicitor, and the solicitor then undertakes that work in the light of those instructions, do you engage questions about the charge? And I fear that we're moving from the principle to looking at the circumstances and whether it's right or wrong for solicitors to accept instructions to pursue such claims. I mean, that isn't the issue before the court with respect. We must proceed surely today on the basis that these are genuine instructions by genuine consumers who want genuine assistance in the pursuit of their claims through a third-party solicitor. And if that is the position, the objective approach that I've sought to take in terms of what are the correct principles are engaged without the sort of jury type points that could be developed as to the nature of the business in this compensation world that we are engaged in. If the charge doesn't apply, then Bott will presumably have to say to clients who want Bott to pursue claims, because there will be clients who want other solicitors to pursue claims, they don't want to do it themselves, then the solicitor will doubtless have to ask for some money up front, the effective equivalent of what would be charged for the damages, maybe a fixed fee or something, in order to pursue the claim. Now that request for in circumstances where consumers don't have the funds to do that, they either can't afford it or do not wish to part with it, is an access to justice issue. The whole point of the civil CFA enables Bott to say, we will do this for free and recover our costs if successful from the other side. We do not need any money now, even though we don't know whether we're going to win or not. And so I'd ask the Supreme Court to bear that in mind. That in the sense, the charge, I submit this charge, the presence of this charge places Ryanair in no worse a position. I mean, it says through Mr. Kennelly that it incurs greater costs, but there's no evidence, findings of that before this court, that somehow these claims are generating excessive costs for Ryanair. I mean, on our side, we would say, as you would imagine, that there is a deliberate attempt here by Ryanair to avoid claims screaming out through the papers. But we aren't in a world where we can resolve those because of the way in which the case proceeded below. There hasn't been that proper debate. And so we have to assume that the claims are genuine claims brought by genuine claimants wishing to genuinely instruct solicitors to pursue them. That's how the test needs to be analysed. Otherwise, we end up with bad law either way, for either Ryanair or for the solicitors. The dispute point, the gainer point, the reason why gainer is important to Lord Justice Lewison's approach is not just the definition of litigation service, that is key, but Lord Justice Dyson in gainer delineated between a case where there wasn't a dispute because there hadn't been a letter for action responded to yet, and one where there is a dispute because a letter for action has been sent and there's been a response saying it's disputed, and it's that line which led him to conclude that's not litigation services undertaken before. And it's the same line which Lord Justice Lewison seeks to impose for the purposes of the application of the charge. That's the relevance of Gaynor. And if Gaynor was wrongly decided on where a dispute begins in terms of the legislation underpinning either Section 58 or the broad sense of where a dispute arises in the context of litigation generally, in the light of the PAPS, Section 58 and the structure which we all work in, then of course we must revisit Lord Justice Lewison's decision, because it would have been based on an incorrect proposition of law as to when a dispute within the context of Section 58 and access to justice arises. There was no dispute in the sense of the Canary cases when the solicitors issued their letters of claim. They didn't know where, as Lord Scott says in his dissenting judgment, when you issue a claim, you don't know whether it's going to be disputed or not. It doesn't mean there's not a dispute to which litigation services are being provided. And here, litigation services are being provided in respect of claims for compensation that the clients, the consumers, believe they're entitled to. That's really what the context is in terms of the dispute. So far as my Lady Rose's point about the distinction, her concern about the equitable charge imposing an obligation on the Ryanair or the third party payer, the tort fees of the debtor, whoever it may be, that they may be required to pay twice. Of course, that's right, but as my Lord Briggs observed, that's in circumstances where either the tort fees or debtor has deliberately connived to avoid paying the solicitor, or B, is on notice of the entitlement to the solicitor to be paid and decides not to pay it. So in that sense, it's irrelevant to the question as to whether or not the charge should arise or not. It's a consequence of the charge arising that occurs, but you have to have, obviously, the ingredients in the case of where a court requires a third party to pay twice. It would have made findings that there's either been some collusion or it's been on notice of the requirement and has not honoured it. There's nothing wrong with that. Ryanair knows from the very outset that this is how the consumer has asked it to pursue the claims, namely to deny.
I think you're coming towards the end of the time frame.
Indeed. Is there any further points you wish to make? Yeah, and I've been asked to confirm, my lords, that the 99% figure that's given in some of the Bott and co material is in respect of litigated cases. I mean, the evidence also reveals the amount of work that goes on to sift cases which are either not pursued at all, which would otherwise have been pursued and failed. And so there is a benefit, just as there is in the personal injury world, of solicitors taking on cases, considering whether they have merit in pursuing them, or advising clients that there is no claim. And that work has a value to society at large and to the consumers individually. And indeed to Ryanair.
Yes, thank you.
They're my submissions.
Thank you very much. Well, thank you both and your legal teams on both sides for your written and oral submissions, which have been of great interest and assistance. The court will take time to decide this difficult case and let you know in due course when a draft judgment is available. The court is now adjourned.